It was more like I asked him to shut off the vehicle and
Oh,
step out of the vehicle.
so he could have told you, "Hey, give me your number. I'll call you later," right?
He could have.
And so you would have just let him drive off, right?
Well, based off of what we saw, once we asked him, the reason for us asking him to step out of the vehicle, that's why we asked him to step out of the vehicle. We observed the open container and we smelled the odor of alcoholic beverage. So
So
I wouldn't have at that point.
your answer is he.
What starts as a routine welfare check on a man sleeping in his car quickly turns into a courtroom battle over constitutional rights. Was this a lawful police investigation, or did officers cross the legal line before they ever had probable cause? As a veteran deputy faces intense cross-examination, one admission threatens to change the entire case. The answer could determine whether crucial evidence stays in court, or is thrown out entirely. Stay with us as we break down the testimony, the legal arguments, and the dramatic courtroom moments that made this hearing impossible to ignore.
So at this point, the call was basically a welfare check.
Yes, yes, sir.
At this point, did you have any reasonable suspicion that offense had occurred or was occurring?
So initially, as the window was rolled up, right, when I got up to that passenger side window, I was like, "Hey, roll down the window." And as we rolled down the
Asked, right?
yes, yeah, as we asked to roll down the window, or I asked specifically, this is when I could smell the odor of alcoholic beverage coming from out of the vehicle. Yeah, that's pretty much what I smelled.
Deputy Trevino testifies that the call began as a welfare check and that he developed suspicion of driving while intoxicated when he smelled the odor of an alcoholic beverage after Mr. Zamaripa rolled down his window. In the 1973 case of Katie v. Dombrowski, the Supreme Court upheld the warrantless search of a disabled vehicle and, in doing so, recognized that a police officer's job involves duties beyond gathering evidence, enforcing the law, and investigating crime, characterizing those duties as community caretaking functions that are quote-unquote totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. So-called welfare checks typically fall into this category of police functions. Now, the Court of Criminal Appeals of Texas applied the community caretaking doctrine to seizures of individuals in the 1999 case of Wright v. State, holding that even without reasonable suspicion or probable cause, an officer may, as part of their duty to serve and protect, stop and assist an individual whom a reasonable person, given the totality of the circumstances, would believe is in need of help. However, the fact that a citizen contact began as a welfare check rather than a criminal investigation does not require an officer to act solely in a caretaking role, as observations made during the encounter, such as the odor of an alcoholic beverage or an open container in plain view, can supply reasonable suspicion that criminal activity is afoot, transforming the caretaking encounter into an investigative detention. This is the sequence that Deputy Trevino described here, testifying that the smell of alcohol coming from the vehicle marked the point at which the deputies began to suspect an offense.
Okay. Did you and Castaneda have a hand signal to show that, hey, there was the odor of intoxicants that was smelled?
Yes, from what I recall, I remember as he rolled down the window, me and Castaneda looked up at each other over the vehicle, and that's when he kind of was like, "Hey, there's like it smells in here." And we pretty much we didn't say anything, but we were kind of leaning more towards like, "Hey, there's something going on here."
Okay. And was this when you started to reasonably suspect that an offense was occurring?
Yes, yeah, we were at that point. Once he gave me the hand signal, I had already smelled the odor of alcoholic beverage, and then from him telling me with his hand, that's when I was starting to think, "Hey."
This is the foundation of the entire case. The prosecution argues that the investigation legally shifted from community caretaking to a DWI investigation the moment the deputy detected the odor of alcohol. Whether that transition was lawful becomes the central legal issue.
Command.
It was more like I asked him to shut off the vehicle and step out of the vehicle.
So he could have told you, "Hey, give me your number. I'll call you later," right?
He could have.
And so you would have just let him drive off, right?
Well, based off of what we saw, once we asked him, the reason for us asking him to step out of the vehicle, that's why we asked him to step out of the vehicle. We observed the open container and we smelled the odor of alcoholic beverage. So
So
I wouldn't have at that point.
your answer is
This is one of the most dramatic moments of the hearing. The admission strengthens the defense's claim that the welfare check had already become a detention, raising serious constitutional questions about when the defendant was effectively seized.
We saw you tell him to turn off the vehicle, right?
Yes, sir.
And then he's out of the vehicle. It's two officers surrounding him, right?
Yes, sir. We were on both sides of the vehicle.
He's trapped between you two and his vehicle, right?
I don't know if you could use the word trapped, but I mean, I would say no, he wasn't trapped. We weren't holding him down or anything like that.
You know what the word trap means, right?
I would think it's like you catch somebody or something, right? And you like hold it there or hold that thing there.
So did you both prevent and did you stand in front of him in such a way that he would have not been able to leave without having to move one of you two?
I guess, yeah, I guess you could say that.
Now, I don't know if you saw it. You wanted him to move in front of the car. Do you remember that?
What was that?
You you wanted him to move in front of the car. Do you remember that?
Yes, at the point of observing the offense, yes, we asked him to go over to our vehicle, in front of our vehicle.
And was that your hand that pushed him forward?
If I'm correct, I didn't push him. I think I might have guided, like I was like, hey, let's go over here.
Did you make contact with him?
That's a hard one to remember. I don't remember if I even touched him. I think I remember guiding him. I was like, hey, sir, step over here for us. But I don't remember touching him. I can't recall that part.
So this is also a command that you've given him, correct?
Yes, after observing the.
This cross-examination creates visible pressure on the witness. His uncertainty weakens the prosecution's narrative and gives the defense material to argue that the encounter became coercive earlier than the officers claimed.
Yes, sir.
You understand what Miranda rights are, right?
Yes, sir.
Okay. You understand that gives a person the ability to answer questions or not answer questions, correct?
Yes, sir.
You do tell them, hey, if you are going to answer me, I'm going to use those answers against you, right?
Yes, sir.
We can agree that nowhere on this video are any of those rights given, correct?
No, sir. Yeah.
Okay. But you did ask him about drinking, right?
Yes, sir.
You did ask him the time of the drink, right?
Yes, sir.
You asked him what kind of drinks, right?
Yes, sir.
Those did go into a report, right?
Yes.
Those answers are being used against him, right?
Yes, sir.
You did come in here with the intention of testifying that you arrested him for DWI, correct?
Yes, sir.
But he was never given those rights, correct?
No, not at the time when we were investigating. No, sir.
But
Although the prosecution later explains why Miranda likely did not apply at that stage, this exchange creates significant courtroom tension. It highlights the legal distinction between an investigative detention and a custodial interrogation.
would you agree that he was concealing anything?
Concealing what?
Would you agree that he was concealing anything?
There was coke that was found that was concealed. Yes.
Would you agree that he concealed his blood the way that it's presented there? Let me back up.
He refused. Yes. If I'm correct, he refused to provide his blood specimen.
Okay, but he already had a breath sample, correct?
Yes.
And so you just somebody wanted to get his blood, right?
Yes, sir. Because we found the cocaine as well.
Even though he blew under, you still wanted to search his blood, right?
Yes. Because
Hang on, time out.
okay.
You didn't have any reason at that point to search his blood, correct?
Yes.
Time out. Did you conduct a DRE test on him?
No.
You had no basis for doing it other than possession, correct?
Yes, sir.
You had no basis to believe that he actually was using cocaine at that time, correct?
Do I have? Can you repeat the question?
You had no basis to believe he was using cocaine at that time, correct?
Yes, possibly I did because he had it on him.
Okay, he had it on him. There are people in your 5.5 years that you've arrested that were not using, but in possession, correct?
That I can't answer.
So then it's a guess, correct?
Yes, yeah.
So you're guessing that maybe he might have it in the system, correct?
It was possible, yes, sir.
This is a critical credibility moment. The defense portrays the blood warrant as based on speculation rather than concrete evidence, placing the deputy's decision-making under intense scrutiny.
Okay, but that's not the standard for that warrant, correct?
The standard.
In other words, you would have had to have known it was in his system, correct?
All right,
Um,
let me ask a question. So in this court, what you're seeking to suppress is the possession of drugs, or are we here for a DWI?
Well, Your Honor, I didn't want to waive anything, but I will be happy to move on regarding the issue that I filed the motion for.
All right, because if it's for the DWI, that needs to be in misdemeanor court. I'm only here to determine, I believe, whether or not this officer had the right to investigate this call that he received, which I'm assuming is under his caretaking duties related to the community. And then from there, this is alleged to have led to a possession of drugs, which is what we're here for. Is that correct?
That's correct.
Yes, Your Honor.
All right, so if we could get to that point,
Thank
please.
you. All right, let's recap real quick. Not illegal to sleep in your car, correct?
No, sir.
Not illegal to sleep at all, correct?
No, sir.
There was no level of distress at all that you saw from Samuel.
No, sir.
And he's in a well-lit place, right?
Yes, sir.
Plenty of people around.
Yes.
Somebody else, if he really needed assistance, could have given it to him, right?
Yes, sir.
And sitting in the car, he's not a danger to himself.
No, sir.
Sitting in his car in the drive-through line, he's not a danger to anybody else.
No, sir.
That's witness.
All right, thank you.
No further questions, Judge.
Is this witness excused?
By the state, Judge, yes.
Yes, Your Honor.
Both sides presented arguments, with the state arguing that Deputy Trevino properly invoked his community caretaking function, and the defense contending that the encounter was an investigation from the outset rather than an exercise of a caretaking function that the law requires to be totally divorced from crime detection. Well, at the conclusion,
This is the legal climax of the hearing. The judge narrows the issue to the officer's community caretaking authority and ultimately rules that the investigation was lawful. The decision allows the drug evidence to remain admissible and clears the way for the criminal case to proceed.